Welcome to Net Neutrality, how the internet as you know it may radically change. My name is Chris Williamson. The goal of this video is to give the average individual a better understanding of what net neutrality is. There are many individuals who don't know anything about net neutrality. My goal is to change that. That being said, I believe that I should state from the outset that I am in favor of net neutrality legislation and cannot completely prevent my bias from appearing in this video. So what is net neutrality? As of now, there is no single definition of net neutrality that is supported by both proponents and opponents of net neutrality and net neutrality legislation. However, most agree that the definition of net neutrality should include these two general principles: that owners of the networks that provide access to the internet should not control how consumers lawfully use the network, and owners should not be able to discriminate against content provider access to that network. So what does this all mean? In essence, net neutrality means that once you connect to the internet through your internet service provider, the internet service provider doesn't care anymore. It's blind and it's stupid. All it cares about is transporting data from one end to the other and nothing in between. It treats all consumers the same and all traffic the same, no matter who it is. This leads to the question, how has net neutrality become a major issue over the past 20-25 years? The short answer is infrastructure. Most people over the age of 20 remember the beginnings of the consumer internet model, beginning in the early to mid-1990s, through AOL, Netscape, etc. What was available to Americans in their homes was dial-up, provided by their telephone companies. Consumers would connect with their computers to their phone line with a modem and access the internet just as if they were making a phone call to another person. Instead, they were making a phone call to the network. However, as most people will remember, dial-up was extremely slow. Web pages would load slowly and often choppily, and watching videos online or streaming music was nearly impossible. Next came broadband, which is still what the majority of Americans have today. Broadband service came through the cable companies instead of the telephone companies, using the existing cable lines. Broadband is about 10 to 30 times faster than dial-up, and allows for faster load times and streaming video. However, even broadband had its downside. Like dial-up, broadband relied on the 19th century creation of the copper wire. The copper wire has been used as a means of communication since the invention of the telephone and the telegram. It's still used by the majority of cable providers for their television service, as well as the source of broadband. The copper wire can handle a relatively small volume of digital data, but is ill-equipped to handle the volume of today's users with their constant video streaming, cloud storage, and mobile services. There is a solution to the copper wire problem, though, and that is fiber optic cables. Fiber optic cables are made out of thin strands of glass to transmit laser bursts at a speed of up to 40 times faster than that of broadband. They've been available since the 1990s and for internet use. However, the majority of Americans still have broadband and do not have fiber optic technology available to them. So, why don't the majority of Americans have fiber optic-based internet running to their home? The answer is that the telephone and cable companies failed to keep a promise they made in the 1990s to reinvest into their infrastructure, creating the fiber optic network needed. In the early 1990s, telephone companies were the only internet service providers. They were also making tremendous profits on telephone services such as caller ID, call waiting, and call forwarding. And under the system of regulations at that time, the phone companies would have to give back that extra profit in taxes. Instead, the phone companies made a deal with the state governments in the states they operated in. In exchange for keeping this extra profit, they agreed to upgrade and improve their networks by creating a fiber optic infrastructure that would run across their states. However, this promise was not kept. Instead, the phone companies pocketed this extra profit, taking almost $25 billion in tax write-offs, with their revenue increasing by 128%. During this time, however, no fiber optic network was ever built. So how exactly did these phone companies get away with this? 3 ways mainly. State regulators basically looked the other way. Regulation was also weakened by the Telecommunications Act of 1996, and that act also created the environment of the late 90s, early 2000s that led to massive mergers of telephone and cable companies. Once these massive companies were combined, most of the fiber plants that were created during this time were eliminated and never replaced. So why does this lack of a fiber optic network matter? Because the current infrastructure cannot handle the massive volume of traffic that Americans require. The increase of streaming media, cloud storage, and smartphone use have left the current network slow and obsolete. So what exactly is the problem then? Why don't we have this fiber optic network? The answer is money. The telephone and cable companies do not believe they should have to pay for the whole cost to create a new fiber optic network. They believe part should be paid by the consumers, the ones who use the network, despite the fact that these same consumers paid for it when the telephone and cable companies took tax breaks in the 1990s. The cable and telephone companies have proposed a solution to this problem, and that is prioritized service. This is different from the tiered services that customers are used to seeing when paying for internet. Tiered services means that the customer chooses the speed the information and the data reaches them. This is basically your difference between a dial-up, a T1, a DSL, etc. However, in all these situations, the network is still blind and stupid. It doesn't treat your information any different. Prioritized service is concerned with the speed in which your content and data is delivered to other users. Phone and cable companies want to charge an additional fee on top of what you pay to access the internet for faster delivery. These companies want to create an express lane that will allow those who pay more to have their information delivered faster to users. So what are the issues with prioritization? The first is the Tony Soprano effect, a term coined by Timothy Wu, professor of Columbia Law, also the man who coined the term net neutrality. Basically, the phone and cable companies are double charging for their services, much like the classic mob insurance scheme. They're charging one price to connect to the internet and another to send data and information across it at a much higher speed. Their justifications: larger internet companies that send out massive amounts of data, like Amazon, Yahoo, etc., and require these higher speeds, should be required to pay more because it taxes their network and thus hurts the average consumer and their internet experience. Another issue with prioritization is the antitrust and economic issues it creates. Since ISPs can charge whatever they want for internet services, they could charge unfair rates that create monopolistic or oligopolistic situations and are anti-capitalistic in nature. For example, an ISP with ties to a company like Walmart could charge Walmart a lower rate for faster service than Amazon or Best Buy. As a result, for consumers, Walmart's website will load faster than Amazon's or Best Buy's. Consumers will be more inclined to shop on Walmart's website because it is faster and less inclined to look elsewhere for better prices. ISPs argue that there would be no reason for them to act this way, and therefore no threat to the digital free markets. Also, by ISPs charging additional fees for faster delivery speeds, smaller companies will be unable to compete with larger companies who are able to pay for that faster speed, creating a barrier to entry in whichever industry. Finally, prioritization has constitutional implications, particularly with the First Amendment and the freedom of speech. If ISPs are allowed to charge whatever they want for faster delivery speed, they could make these decisions based on biased political interests. For example, an ISP that is conservative could charge a lower rate for a faster speed to a conservative website while charging a higher rate to a liberal site. While this may not affect the larger sites like a Fox News or a CNN, it could be crippling to the smaller, independent blogs who still receive heavy traffic in terms of site views. Basically, prioritization is the fundamental opposite to net neutrality. It controls how consumers lawfully use the network and discriminates against content provider access to that network. As the ISPs began to try to institute their plans for prioritization, the battle for net neutrality truly began. Proponents believe that legislation by Congress or policy changes from the FCC was the only way to prevent the ISPs from damaging net neutrality. They believe that the internet can only stay neutral if the government intervened and acted to restrict the ISPs. Opponents to net neutrality legislation believe that this was an overreaction to a hypothetical possibility. They believe that government intervention would ruin the neutral nature of the internet that already existed. And they also believe that there was no inclination that ISPs would act this way, nor would it be in their best interest to do so. It's important to note that opponents of net neutrality legislation are not necessarily opponents of net neutrality in itself. The list of those in favor of net neutrality legislation is very broad and very long. It includes names like Google, Amazon, Yahoo, independent blogs like MoveOn.org, President Barack Obama, former Senator Olympia Snowe, and Representative Ed Markey have both tried to pass net neutrality legislation. Internet pioneers like Vinton Cerf and Tim Berners-Lee have also been in favor, as well as many professors and John Podesta, former chief of staff to President Clinton. The list of those opposed to net neutrality legislation is equally long and equally broad. ISPs have been the most outspoken against net neutrality legislation, and those include Comcast, Verizon, and AT&T. Many representatives and senators have also fought to block legislation from passing, including Fred Upton, John McCain, and Jim DeMint. Mike McCurry, former press secretary to President Clinton, has been outspoken against net neutrality legislation, as well as many other professors. So now we come to the legal jurisdictional question. Who exactly can regulate the ISPs? Simple answer is the FCC, the Federal Communication Commission. Congress has given them the power to regulate the internet, but the real question at this point is how much can the FCC really regulate the internet and the ISPs? Although the internet is relatively young, particularly with regard to its use by the average consumer, the FCC's role in internet regulation and net neutrality has changed over the years, essentially going through 3 different eras. The first era begins at the very beginning of the internet. The FCC draws its power to regulate the internet from the Telecommunications Act of 1934. When the internet originated, it was considered a common carrier service, just like a telephone call, a telegraph, or even electricity. The internet had to treat all information and data equal, just as all electricity had to treat whatever you plugged in equally, and all telephone circuits had to treat every call equally. Because the internet was considered a common carrier service, the FCC could regulate the internet under Title II of the Telecommunications Act of 1934. Title II is much more strict and stringent than the other titles of the Act, and allowed the FCC to heavily regulate the ISPs, basically acting as an internet traffic cop to ensure neutrality. The second era, or the Powell era as I'll call it, began in the late 1990s when things began to change drastically. As previously stated, the 1996 Telecommunications Act created an environment that led to the massive mergers of phone and cable companies. These merged companies now had more money to use on lobbyists in Washington and began to push for their agenda. The next major shift occurred with the appointment of Michael Powell as FCC Commissioner in 2001. The son of Colin Powell, he led major deregulatory efforts which allowed the telephone and cable companies, among others, to be subject to far less regulation from the FCC. Easily the most severe hits to net neutrality occurred from 2002 to 2005, with the 2002 FCC ruling that cable television broadband service is an interstate information service and therefore subject to Title I of the 1934 Act, not Title II. This ruling was subsequently upheld by the Supreme Court in the Brand X case in June 2005. In August 2005, with Powell no longer commissioner, the FCC was forced to extend the same regulatory relief given to cable companies to telephone companies who provided internet service. As a result, the regulation of the internet and their service providers now lies completely within Title I of the 1934 Telecommunications Act. So what exactly are the differences between Title I and Title II of the 1934 Act? Title I states that the Act applies to all interstate and foreign communications by wire or radio, and the legislative history of the Act indicates the FCC has regulatory power over all forms of electrical communication, even those not explicitly mentioned in the Act. Title I confers upon the Commission the authority to promulgate regulations reasonably ancillary to the effective performance of the Commission's various responsibilities outlined elsewhere in the Act. On the other hand, Title II imposes certain specific requirements on common carriers in their provision of telecommunication services. Generally, Title II requires common carriers to provide service upon reasonable request therefore and at a just and reasonable rate. Common carriers are also required to provide services without unjust or unreasonable discrimination in charges, practices, classifications, regulations, facilities, or services. In addition, the Act requires certain carriers to provide potential competitors with access to their network. Entities regulated under Title II may also be subject to additional requirements governing universal service support, the provision of disability access, public safety, consumer protection, and law enforcement access. So what does this shift to Title I really mean? It means that cable operators providing broadband internet access and phone companies providing similar service are not subject to the myriad of regulatory requirements mandated under Title II of the Act. Most notably, providers are not obligated to provide unaffiliated internet service providers access to their broadband platforms. In addition, providers remain free, at this point, from provisions governing discrimination in the provision of services, universal service support, assistance to law enforcement in the interception of communications made over the network, network accessibility to individuals' disabilities, and the protection of subscriber information. Basically, the internet service providers have free reign on their networks. The next era, and current era, began in early 2005, and this is the era of the FCC to fight to regain regulatory power. In early 2005, Michael Powell resigned and was replaced by Kevin Martin, who got rid of most of Powell's staff. Martin sought to regain the regulatory power of the FCC over the ISPs and to codify neutrality regulation. After the August 2005 ruling that grouped telephone companies with cable companies that provided internet service, Martin and the FCC issued a policy statement on network neutrality. The policy stated that the FCC still had power to regulate ISPs under Title I and would do so to make sure ISPs acted in a neutral manner. In this policy statement, the FCC adopted 4 principles towards net neutrality, all with the preface to encourage broadband deployment and preserve and promote the open and interconnected nature of the public internet. These principles are that consumers are entitled to access the lawful internet content of their choice, that consumers are entitled to run applications and use services of their choice, subject to the needs of law enforcement, that consumers are entitled to connect their choice of legal devices that do not harm the network, and that consumers are entitled to competition among network providers, application and service providers, and content providers. The FCC quickly put these new principles into action, leading to the first and only Supreme Court decided net neutrality case, Comcast vs. FCC. In 2007, several Comcast subscribers discovered that the ISP was interfering with their use of peer-to-peer programs because of the amount of bandwidth these programs required. 2 advocacy organizations filed a complaint with the FCC, while Comcast insisted it was within its right to manage its network capacity. After hearings were held, the FCC ruled that it had jurisdiction over the issue, that Comcast significantly impeded its consumers' ability to access content and use the application of their choice, that Comcast had several other options they could have used to manage network traffic without discriminating against peer-to-peer communications, and the FCC could resolve the dispute through adjudication rather than through rulemaking. Although Comcast complied with the order, it appealed it, with the case reaching the Supreme Court. Supreme Court ruled, reversing the Circuit Court's decision in Comcast's favor, overturning the previous FCC ruling. The court stated that the Brand X decision still applies and that ISPs are regulated under Title I, and therefore the FCC has ancillary power to regulate them. The FCC may exercise ancillary jurisdiction if the Commission's general jurisdictional grant under Title I covers the regulated subject and the regulations are reasonably ancillary to the Commission's effective performance of its statutorily mandated responsibilities. In this case, the Supreme Court ruled that the FCC's application of ancillary authority was too expansive. The FCC did not assert ancillary authority based on the narrow scope of regulatory power. Instead, the FCC asserted its ancillary power to ensure reasonable rates, something they have no express regulatory authority over within Title I. After the Comcast decision, the general sentiment was that the FCC had lost all authority to enforce net neutrality regulation, and that it would have to regulate on a case-by-case basis. It appeared as though the FCC had lost their fight. However, the FCC refused to give up. Just a month after the Comcast decision, FCC Commissioner Julius Genachowski stated that the FCC would not give up the fight. Genachowski stated that the FCC planned to take a third-way approach between Title I and Title II. In December 2010, the FCC voted to pass a new order to strengthen their ability to regulate net neutrality. Before the order was even officially published, Verizon and Metro PCS Communications appealed the order. In September 2001, the order was published in the Federal Register, taking effect on November 23, 2011. The order contained 3 overarching principles that applied to the Commission's new rules on net neutrality. Firstly, transparency. Fixed and mobile broadband providers must disclose the network management practices, performance characteristics, and terms and conditions of their broadband services. Next, no blocking. Fixed broadband providers may not block lawful content, applications, services, or non-harmful devices. Mobile broadband providers may not block lawful websites or block applications that compete with voice or video telephony services. And finally, no unreasonable discrimination. Fixed broadband providers may not unreasonably discriminate in transmitting lawful network traffic. So, what does the future of net neutrality and net neutrality legislation look like? It's certainly brighter than after the Comcast decision. However, this debate is far from over. The FCC still faces legal challenges in its future from internet service providers and their lobbyists, and their new rules have yet to face final deciding litigation in the Supreme Court. In fact, they've already seen instances of ISPs slowing down individual services. Net neutrality legislation is far from a decided issue, and its future will shape the internet and society in the 21st century. As more and more individuals rely on the internet for more and more of their lives, and as lives become more digital in nature, net neutrality is only going to become bigger and more prominent in American political culture. I want to thank you for watching this video. Hope now you have a better understanding of what net neutrality really is and how important it is to the future of this country.